Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Welcome to another episode of Trust Me, It's Complicated. I am your host, John Marshall. I am the owner of Marshall Law here in Wildwood, Florida, which is Central Florida, for those of you who don't know where Wildwood is. But thank you for joining me today. And today we're going to talk about the wonderful world of powers of attorney. And I say that somewhat in jest because I can be a bit sarcastic, but also because, to be honest with you, it's one of the most favorite topics I have to discuss. And that's because powers of attorney are really, really misunderstood. And they are truly powerful documents that everyone age 18 and over should have. And I say that because when a child turns 18, even though they may be your child, they are legally an adult. And so at 18 years of age, you are no longer considered their natural guardian. That immediately ends. So your child's bank account, you can't access because you're not their natural guardian. If your child is injured and you take them to the doctor or the hospital, you have no right to information regarding them because you are no longer their natural guardian. You're their parent, but your rights as a guardian have terminated. Now, my niece, when she turned 18, her uncle gave her the best gift he could ever give her, a brand new power of attorney. And yes, we got her a real gift, so don't worry about that. Now, when my next niece turns 18, she will get the exact same thing as well. And that's because heading off to college, they need to have the documents in place that if they need someone to step in and handle things financially for them, whether it be their student loans, whether it be, maybe a meal plan, or maybe it could be something even more complex like an insurance claim, health insurance claim, things like that, that power of attorney is needed. And it's needed by the parents. Now, as we progress in age, as we get older, as we reach middle age, like I am, we still need the power of attorney, but who we appoint is going to change over time. So for me, it's my spouse. And then because I don't have kids, I have my parents. But as my parents age, I may modify that to be maybe my sister, my brother, my brother-in-law, and so forth. Now, what makes a power of attorney so important? Well, plainly this. If I am incapacitated and I need somebody to pay my bills, how do they access my bank accounts to do that? How do I authorize someone to file my taxes on my behalf if they cannot legally sign my name? That is the purpose of a power of attorney. Now, we oftentimes think of it in context of, well, I'm incapacitated, meaning, mentally I'm not able to, complete the function for which I need that agent to act. And I say agent because the person giving the power is the principal, the person receiving the power is the agent. Probably a better way to think of that is employer-employee, okay? But principal, agent. Now, most times we think of it in terms of I'm incapacitated, meaning I don't have mental capacity to handle those things. But quite frankly, under Florida law, we do not tie it to an event, meaning that if you sign a power of attorney, it is effective immediately, okay? So, as the old saying goes, choose wisely. Okay. And when we say that, it's because the person you're giving the power to has the ability to transact a lot of business and authority on your behalf. So in my power of attorney, I have my wife named as my agent. We are in the process of buying a home. Let's say for some reason we're supposed to close, but I get an order, call from the court that there's an emergency hearing and I have to be present. I'm not worried about it. I'm going to go to the hearing. My wife can handle the closing on my behalf because she can sign my name, Patty Marshall or John Marshall by Patty Marshall as agent. And it has the same legal authority as if I signed it. Okay. So again, I don't have to be incapacitated. It's just actually a good document to have almost for everyday, activity, especially amongst a married couple. Now, if I do become mentally incapacitated, I don't have to worry about it. My wife is authorized as my agent with backups in place. And then because the power of attorney can be amended at any time, as life progresses, we may change who we have in those various roles. Now, when we, talk about a Florida power of attorney, it is different than powers of attorney done in most other states. I practice law in Ohio as well as Florida. Um, I love Ohio. I grew up there. It's flat and there's corn and cows. Okay. And the best college football team in the country, the Ohio State Buckeyes. However, I love living in Florida. I love practicing law in Florida. I love living in Florida. This is my home state. And to that extent, I adopted Florida State University as my team down here. But I digress. Getting back to the subject at hand, one of the things I like to point out is a Florida power of attorney is vastly different than what you have in most other states. One, a Florida power of attorney executed after October 1st of 2011 must have specific enumerated authority for your agents to perform certain actions. Now, I'm not going to get into every one of those actions, but there are some very important ones in there. So, for example, if I need to go on Medicaid because I need skilled nursing care, and that skilled nursing care costs around $12,000 a month, and I can't afford it, well, who can do Medicaid planning on my behalf? If my power of attorney contains very specific language, I can authorize my agent under the power of attorney to do my Medicaid planning. Well, what if I need somebody to address my IRAs? Let's say I'm over, a certain age, I'm over 73 and I have to take a required minimum distribution out of my IRA, but I'm incapacitated. I have to have specific enumerated authority in that power of attorney that allows my agent to make sure my RMD comes out every year. And one of the biggest areas that really requires specific enumerated power, meaning initialing and granting that power purposefully, is gifting. Now, this is the one area of powers of attorney that I find most ripe for abuse. In fact, one of the worst cases I ever saw of this involved a mother whose estate was worth around $2 million. She had two children. One was a literal rocket scientist. He was living out working for a rocket company in another state, but a literal rocket scientist. Her other child was an attorney for the state of Florida. That child had power of attorney for mom. That child was the agent to mom, the principal. The power of attorney just blanketly said, my agent can make gifts on my behalf. That agent transferred by gift $500,000 to themselves over a year to a year and a half period. Mom dies. Son thinks I'm inheriting half of a $2 million estate. No, the estate's now $1.5 million. So he's getting $750,000. The other sibling's getting $750,000, but they also pocketed away $500,000 using the gifting power under the power of attorney. And they knew exactly what they were doing. And they were very clear about it. I had authority. Mom said I could do it. You know what? Power of attorney said it could be done. And even though son filed a lawsuit and was pursuing it, he did not prevail because mom signed the document giving the other child authority to do that. So we want to be careful. Just because a power can be in a power of attorney, should it be in a power of attorney? Okay. Well, that's where talking to an attorney that actually sits down and goes through the document with you to discuss it can address those concerns. So a lot of my powers of attorney, we take out the ability to make gifts to the agent's family. They can't pay somebody else's tuition. They can't pay somebody else's medical bills. But we still leave gifting powers in there for Medicaid planning purposes. And that's because if we create something like a Medicaid Asset Protection Trust, we will actually use federal gift laws to transfer assets out of the principal's name into the Medicaid Asset Protection Trust. And so we still need to have gifting powers, but we want to craft a power of attorney that says, yes, you can have the gifting authority for purposes of Medicaid qualification, but we do not want to grant gifting authority for purposes of you pocketing personally my money. These are things that most people's attorneys never talk to them about. And that's because a lot of attorneys are come in, pay me my fee, here's the fee, sign these documents, out the door. Well, we want to have that conversation. One of the things that a lot of clients don't want to do is, hey, if I'm giving $50 a month to this charity, well, if I'm incapacitated, I want my agent to use my money to take care of me. Stop giving it away to a charity. Okay. But if I have a client, like I had a client one time, he said, but I give 10% to my church out of every paycheck. And I said, well, okay, paycheck, RMDs and all that, his retirement, Social Security. So we modified it. And we said, yes, the agent can make gifts to the church, but it is capped at 10% and it is based upon the income received, by this gentleman. So we want to look at what a power of attorney is intended for, but also in what ways can we narrow the power that's given, and what other ways can we expand the power that we're giving. Like I said, sometimes I draft a power of attorney and it has business language in there. And the person goes, well, I don't have a business. Why do I need to have business language in here? Well, here's the funny thing. I'm in the villages. Most of my clients are retired. I've had more than a few clients start a little business in their garage. And the next thing you know, they're making $50,000 to $100,000 a year off of their 3D printer, because what little side project they started with has now blossomed into a business. And, so again, we don't know. These are things that we have to talk about and we need to look at. Now, the other question is, well, who do I appoint? Again, we want to talk about, well, is it your spouse? For me, it's absolutely my spouse. She not only is my best friend, she works with me here at Martial Law. If you call the firm and you talk to Patty, that is my wife. If you see Patty, you're going to realize she is way out of my league. Okay. So, but again, I give power of attorney to her and she's given power of attorney to me. And I'm blessed that I have family members that I can turn to and trust to give that power to. But I can tell you, if I had a family member who had a history of drug or alcohol abuse, I'm probably not going to give that to them, because even if they're in, let's say rehab, or they've been sober for a while, if they have a relapse, I'm now jeopardizing a lot of my assets to them. If they have a gambling addiction, okay, we don't want to give them that authority. If they've had problems with their own finances, if they live paycheck to paycheck, or they've had some bankruptcies, does that make them a bad person? No, it doesn't. But at the same time, maybe I don't want to give them authority over my assets. So these are things that we need to think about. Now, sometimes people will say, well, you know what? I don't need the power of attorney because I just put my kid on the bank account, or I just put so-and-so on there as a co-owner on that bank account. They don't need that power of attorney paperwork in order to pay my bills. Well, there's Murphy's Law, the law of unintended consequences, okay? And one of the things that I tell people is, that sounds great in theory, but life is not theory. Life is reality. And let me give you another example. I had a lady who say, hey, I've got power of attorney. She told her daughter, she said, daughter, I've got power of attorney. You now can transact business on my behalf when I need you. Sorry, it was my parents calling. So anyway, daughter says, Mom, don't worry about it. I just put me on your bank account. We don't need that stupid piece of paper. And daughter convinced mom not to do it. 3 months later, mom is calling me. What do I do? $9,000 has gone out of my account. And I'm like, well, where did it go? Well, my daughter got sued and there's a judgment against her, and they went in and took it out of my account. And I said, well, hold on. Your daughter is the agent under the power of attorney. They can't just come and take money. The agent merely acts on your behalf. They're not an owner. And she goes, no. We didn't use the power of attorney. We just put my daughter on the account as a co-owner. Guess what? You're not getting the money back. And even if we sued and we got the money back, you're going to spend probably $4,000 or $5,000 to get $9,000 back. Really, at the end of the day, it's not a winning scenario, because you can also lose, and now you're out another $4,000 or $5,000. This is the problem that a lot of people don't think about. They think, well, I'll put kids on an account. Here, let me give you another example. This is one of the worst examples I've ever come across, and it's all true. I had a lady come into me. She said, my dad put me on 3 accounts, 3 CDs. $100,000 each one. One for my brother, one for my sister, one for me. But he put him in my name, and said, when I die, you gift these to them. And I said, did you agree to that? She goes, yeah. She said, but do I have to? And what's my legal answer? Because I represent her. No, you don't have to. You are the owner of that. You didn't sign a contract. There's no binding agreement. So what's going to happen? Well, she did give her brother and sister something. A letter full of a lot of words, telling them how she felt. She kept all the money. Found out that 4 months later, she died of cirrhosis of the liver. Now her kids are inheriting from her estate the money that came from her dad that was supposed to go and be shared with her siblings. This is why a power of attorney is important. It keeps the assets titled in the name of the person who is the principal. It keeps the other person in a position where they can handle things on your behalf without becoming an owner, so that, one, if they misuse it, now we have a legal right to go and demand that money back because it was not their money to begin with. They were not the owner of it. But two, there are other factors at place here. That gentleman who died, had it gone through his estate, rather than gifting it to or leaving it to his daughter to gift it to others, that would have been actually enforceable, and his other two children would have inherited the shares that he intended for them. So we want to use a power of attorney, one, to make sure that people can transact business on your behalf if you're incapacitated, or maybe you're just not available. Think about this. My father-in-law, he wasn't incapacitated mentally when he was in the hospital. He just wasn't in a position that he could get up, leave the hospital, go to the rehab facility and sign contracts to go get rehab there. But my wife could. So she signed the contracts as the agent. And that had the same legal binding effect as my father-in-law signing it. And yet my wife was not personally liable for any of the bills or anything that came out as a result of that. He was. So we want that power of attorney in place to make sure that people can handle stuff on our behalf, but we're also doing it without giving them an ownership interest, meaning that we don't jeopardize other aspects of our estate plan. And even if, let's go back to that scenario where the daughter kept the money. Let's say she didn't keep the money and gifted it out. She would now be subject to IRS reporting requirements on gifting of assets in excess of a certain limit. So you went from having assets in an estate subject to estate tax that would not have required any reporting because his estate wasn't taxable, to a situation where she would have been required to file a gift tax return and notify the IRS of the gift and possibly have to pay gift taxes. So again, there's a lot of moving parts on this. But that's why a power of attorney is a very, very important part of your estate plan. But avoid just going in and getting one, having one, and not having one crafted to your particular needs, or one that isn't crafted after discussing these particular aspects of your estate plan isn't the fix. Maybe it's a Band-Aid, or maybe you're setting yourself up for even worse problems by enabling someone to do things on your behalf that you don't want them to do. So again, you want to have a power of attorney, but you want it drafted by an attorney that you talk to and that you to speak about these issues, so that a power of attorney that you sign addresses your unique situation and your unique family or friends. Okay? So with all that in mind, we'd be happy to talk to you about this. Feel free to call us. My name is John Marshall. My law firm is Marshall Law. Our phone number is 352-432-8859. And you can find us online at marshallawpa.com. And the next time I do this podcast, my phone will be silenced, because you never know when your parents are going to call, even when you're in your 50s. Thank you. Have a great day. And if you hear this and your parents are still with you, give them a call. Tell them you love them. Enjoy every second that you can.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.